Can a son claim a share in property standing in his mother's name simply by saying it was bought with his father's money? Imagine a family house purchased decades ago, registered in the mother's name, lived in together for years, and much later questioned as a Benami transaction. This is the story of Sekhar Kumar Roy versus Leela Roy and another, decided by the Calcutta High Court on 7th June 2023. The property was purchased in 1969 in the name of the mother while the father was alive. The father later died intestate in 1999. More than 4 decades later, in 2011, the son filed a suit against his mother and sister seeking declaration and partition, claiming that the purchase in his mother's name was only Benami. The trial court dismissed the suit and the son carried the matter in first appeal to the Calcutta High Court. The High Court held that merely showing that the mother had no independent income is not enough to prove a Benami transaction. The burden squarely lies on the person who alleges Benami to prove who paid the consideration and, more importantly, what the real intention behind the transaction was. The law presumes that the person in whose name a registered sale deed stands is the true owner. Even if a husband provides the money, that fact alone does not make the transaction Benami. What must be proved is a clear intention that the husband alone was to retain ownership. Suspicion, assumptions, or family beliefs cannot replace legal proof. Since the son failed to produce documents, proof of payment, or evidence showing Benami intention, the appeal failed and the mother's ownership was upheld. This is how courts decide property disputes, on evidence and intention, not emotions. Subscribe Nava Legal for judgment-based legal awareness.